with my clients, I put a big effort and focus on solving problems and what can we do. So knowing your rights is really important, and knowing how you can enforce them is really important, but actually solving the problems, I think, and having them go away before they grow into bigger problems is way more valuable, in my humble opinion. So what I thought I could talk about that might add some value for you would be practical tips for securing accommodated employment. So this was the question we had. How do we ask? What can we ask for? That's what we're going to talk about now. And in my view, the best approach is to help the employer accommodate you. And so whenever I'm going into a difficult discussion, or I'm talking to clients who are going into a challenging situation, I always encourage them to take a positive approach and to try to help the employer get to where you want them to be. And so we're going to talk a little bit about what that looks like pre-employment, so that's before you get the job, so you're making the job application or you're attending the interview, and also during employment, so once you already have the job, what might an accommodation request look like. One important point, and I get this question a lot, is are job applicants, are you required to disclose that you have a disability? So when you're applying for a job, do you have to say in the job application or on your cover letter that you have a disability? And the answer is absolutely not. You do not have to disclose that information. And depending on your disability and how visible it is, you might be able to help the employer accommodate you, because that's my focus, help them accommodate you by getting the job and then showing them that you can do it. And so where they might have screened you out due to bias or discrimination, if you don't disclose that information up front, then you're one step closer to getting the job and showing them that you can do it. I think what that does is it puts the onus a bit on you, if you have a disability or other limitations, to apply for jobs when you feel comfortable that you can do the core functions of that job. And so just like, I wouldn't apply for a job doing neurophysics or brain surgery because I can't do that job. I don't have those skills. I think the same analysis can apply to physical abilities or mental abilities. So you want to self-assess and say, is this a job that I can do the core functions of, as a starting point to set yourself up for success. But what you don't want to do is rule too many things out. So there's kind of a sweet spot in there. And so the idea that, the job posting might have 9 things that they're looking for, and one of those 9 things you're not sure if you're going to be physically capable of doing, well, you could still apply for that job, and that might be something that can be accommodated. I would say minor modifications are more likely to be accommodated than major ones. So again, these are things to think of when you're looking at jobs and you're thinking, is this something that I might apply for, and can I do this job? If you have a visible disability, or if you're going to disclose the fact that you have a disability that's not visible, be prepared with information to dispel myths and sell your skills and capabilities. And my approach is always very positive. So focus on what you can do as opposed to the things that you can't do. A lot of discrimination that I hear about, and I've heard about in the last session that we talked about here, was about stereotypes, like things that employers think that you can't do. Like if you're in a mobility advice, does that impact your brain and how you can think? And so be prepared to be upfront and dispel some of those myths, and talk about the things you're great about. You're great at. So you need to put the focus on what you do have to offer and what you can do, and be prepared to toot your own horn a little bit. Now we're talking about a job that you already have. And so you have a job and you need to ask for an accommodation. So some kind of change or modification or equipment that you need to be able to facilitate you doing your job. And I always say go with a strategy, right? So anytime you're entering into a discussion where you're going to ask for something, you want to do that strategically. And you want to think about what is your goal. So I always start with a goal. My goal is for the employer to give me this accommodation that I'm looking for. Okay, so how can I set that up to get the goal that I want? And you want to consider things like who is best to ask. I get a lot of clients ask me this about all kinds of things, like, well, who should I ask? Who should I address my email to? Or if I'm writing a demand letter, who should I address it to? Or if I want a raise, who should I ask? And I say, you ask the person who's most likely to say yes. Maybe you have a direct supervisor, maybe there's a manager who's above that, maybe there's an HR department, maybe there's an owner. And you think, okay, I need this change, who do I ask? Do I have to go to my supervisor? Do I have to go to the owner? Do I have to talk to HR? And again, I always think about who is most likely to say yes. And that's the person that I would suggest that you ask. When is best to ask? Well, when should you ask for it? And guess what my answer is going to be? When is the person most likely to say yes? That is when you would ask. And what should you say? Again, what is the person, what can you say that is going to make it most likely for them to say yes? So you always start with identifying your goal. I want them to say yes to this, and then work back and think about the best plan to take of who to ask and when to ask and what to say based on the goal. And I even recommend writing that down and maybe talking to a friend or someone, a trusted colleague about it to bounce that off. You can certainly get legal advice about those kinds of things if you want. I love giving clients advice on these kinds of conversations. And when I'm thinking about strategy and communication, I'm always thinking about the other person. So what are they thinking? What do they want? What are their needs? What are their priorities? And how can I make what I'm asking for fit into what they want and their priorities? So that's a really good approach to take when you're trying to convince someone to do something. One way to level the playing field when you're dealing with disability at work is to take control. And so go in and take control of the process. And how can you do that? By being strategic, which was the last slide, and by bringing information and solutions to the table. So educating your employer about your disability and what your limitations and restrictions are. In general, I find in the workplace, people are afraid to ask. Like, I know that you might know that you have a disability, I might see you struggling at work, but I don't know what to say and I don't know how to ask about what it is that you might need. I might be guessing about what you can do or what you can't do. And so as the person who has a disability, who has restrictions and limitation, you're the best person to know what you can and can't do. And so bringing that forward and putting that on the table, if you're needing some accommodation, is a great way to start. Give concrete and credible information, ideally from your doctor. So if you have specific requirements that are medical in nature, that information is going to be respected the most if it comes from your doctor. This is not to say you need to bring your doctor into work or let your employer call your doctor up, but a note that says, these are the accommodations that are required from a medical perspective is going to have a lot more power than it coming verbally. Also, I find even taking that back a step, talking to your doctor about what it is that your limitations and restrictions might be, because I do find some people also are sort of working with their understanding, which isn't always in line with what their doctor thinks is best as well. Bring solutions to the table. So most bosses are busy people, and they don't want to think about how to solve other people's problems. They're too busy trying to solve their own problems. And so anytime you're bringing a request or a problem, bring a solution with it. Like, I'm having trouble navigating through the doorway, and it's not working for me. Well, if you bring that to the employer, then now it's their job to think about, okay, how could we solve that problem? Whereas if you come to them and say, you know, I'm having a problem navigating the doorway, you know what, with the measurements of my mobility device, actually this is the width that it would need to be for me to get through safely, and hey, I happen to know a contractor that does that kind of work, for instance. Or this is the door that I go through the most often. If we could just do this one, I don't need all the doors changed. You know, again, bringing a solution forward that's specific, it makes it easier for the employer to say yes, because they know specifically what it is they're saying yes to. Another way to take control is to set meetings, offer support and information, and drive the process. So that doesn't mean you want to be at your boss's door every single day saying, remember me, this is what I need, this is what I need today, here's what I need today. It's more about, you know, you have that initial discussion where you propose a solution and you say, you know what, could we get together again in another week and talk about this? Or if it's more timely, you know, maybe we can circle back tomorrow. Can I send you some more information? Is there something I can do next to help keep this moving, or suggest how you might keep it moving? Because employers, you know, I often say employees don't come with a manual, and bosses are just people, and they don't have all the answers, just like we don't have all the answers. And so what you can do is help them, and that is also in your selfish best interest, because it helps you get what you need to stay in the workplace. So secrets to successful accommodations. And so again, this is all part of a communication strategy in talking to an employer about accommodation. Consider the impact of the business and other employees before presenting suggestions. So I would suggest that before you go in to talk about an accommodation, you think about, what is it that could work for me? Try to come up with maybe a few solutions, and think about what impact is that going to have on the business or on other employees. So you've already thought through some of the barriers or some of the objections that might come up. Give a few alternative accommodation ideas if possible. Don't give 100, don't even give 10. But I find sometimes strategically, it's nice for the boss to feel like they're in control, right? So if you give them a few choices, like 3 maybe, that all would work for you, then they can still be the boss and pick the one and feel like they're in charge. Ask the employer for their ideas and listen to them. So, you know, the flip side of me saying, okay, you want to go in and be in control of the process is, again, you want to let the boss be the boss and say, okay, here's my ideas. Do you have any ideas? And be open to listening to them. We talked a lot about the legal principle that you're not entitled to your perfect accommodation. So you don't get to go in and demand, this is what I want, and it has to be only this. And accommodation is a two-way street is another expression that's used a lot. So both sides need to be open to talking and listening to what the other side has to say. I already hit my next couple points. Make it easy for the employer to try it. So if there's a way to adjust something temporarily, for instance, you know, that's harder with physical changes to the workplace, but if we're talking about a schedule change or a readjustment of duties, like I can't do this one out of the 9 things that are in my job, so could we try giving that duty to someone else? If you can, one way to do it is to suggest doing that on a temporary basis. Like, could we just try this for a few weeks or a few months and then reassess and see how that is? If there's resistance to change, then it's easier for an employer to agree to do something for a short period of time, and then hopefully what everyone will see from that is that it works, and then you can ask, or maybe it'll just never get revisited again, and you can just carry on doing it the new way that works better for you. And again, focus on the things you can do and how you can contribute. So, you know, I always say lead with a positive, right? So I'm been using this situation where you can do 8 out of the 9 things that are in your job. Maybe start the discussion by talking about the 8 things and how much you're enjoying them and what good feedback you've got about them, and then deal with the 9th thing. Just to sort of demonstrate that you can do things and you are contributing, and rather than keeping the focus on the one thing that you can't do. And in this scenario, just to set the scene, I am a worker who needs accommodation, and I have post-concussion syndrome, which means that these fluorescent lights give me really bad headaches. And Laura doesn't know this about me. She is very busy, a very busy lady, who is, you know, we don't know each other that well, but we've met, right? Hi, Laura. I was hoping to talk to you.
Oh, Sarah, this is a bad time. I'm in the middle of a big project right now, and I just don't have time to talk to you.
Well, I've got a really big problem. And so it kind of has to, it really has to happen right now.
Can we talk tomorrow?
Well, I'd rather really talk to you about it now. And here's my problem. These lights are giving me terrible headaches.
Sarah, we all get headaches. I've got a headache right now like you wouldn't believe.
Well, the headaches are really bad for me. They're actually worse for me. And so we're going to need to change out all the light bulbs.
Change out all the light bulbs? I don't even know where to start with that. This is a shared work environment. We've got all sorts of other people here. What do you want, everyone working in the dark?
Well, I can't keep working here if I get these headaches, so I'm just going to have to leave and I'm going to go on sick leave. And when you're ready to change the light bulbs, maybe I can come back to work.
Scene.
Yeah, I think we just completely started off on the wrong foot there, and it just went from bad to worse, and then I left, and you know, Laura and I both have a lot of experience in these kinds of human rights things, and you know, maybe I was feeling stressed out and I didn't know how to ask, so I just asked in this terrible, unproductive way. I obviously was thinking a lot about myself and what I needed, and not as much about what Laura was thinking or what information she needed. And oftentimes those situations, it's really hard to turn that around at that point, once you've had those started off that way, and people will go on sick leave and sometimes, unfortunately, not ever come back to that workplace because they feel that Laura's not seeming very welcoming to me either. So we've taken a problem and we've made it bigger, and we've moved farther apart instead of moving closer together. So let's try scene 2 and see if we can do this a little bit better. Knock, knock, knock.
Hi, Sarah. How are you doing?
Hi, Laura. You know, I have something I want to talk about.
Sarah, I'm in the middle of a big project. I've got a deadline at the end of the day. Could it wait?
Yeah, you know what? It definitely can. Is tomorrow morning, would that work?
Tomorrow morning would work.
Okay, how about 9 if I come back then?
Sure.
Okay,
Let's
great.
talk then.
Thanks. Good luck with your deadline.
Thank you. See you then.
So already better, right? Now I'm coming back. Okay, it's 9. Hi, Laura.
Hi, Sarah.
Hi.
I was expecting you. Thanks for holding on to your issue. What did you want to discuss?
I wanted to just come and talk to you. You know, it's been 6 months now that I've worked here, and I'm really enjoying it. I have very good feedback on my data entry. I get my error results back, and they've been getting better and better, and I just really appreciate the support I'm getting here, so thank you.
That's great. We're hearing great things about your performance.
Awesome. So there's one small issue that I'm having, and I'm hoping that we can maybe work together to fix it, so that I can keep going with the good data entry. So you may not know, but I have post-concussion syndrome, which is a long word, but really what that means is I hit my head, and mostly I'm totally fine, but I do have some problems with fluorescent lights. And what happens is, unfortunately, I get really bad headaches, and that makes it really hard for me to keep working. So the other day I had to go home sick. I don't know if you knew about that, but it was the headaches from the lights. So I have given this some thought, and there are actually, the Canadian Brain Injury Association has some information, which I'll give you here if you want to look at that, but I've already read it. And what it says is there's this new kind of light bulb that's not fluorescent that should totally work to eliminate my headaches completely. And so I'm hoping that maybe we can put some of those in here.
Well, I mean, this is a pretty big office, and we've got these fluorescent lights all over the office. That would be a big undertaking for us to replace all of the lights in the office.
Yeah, I totally appreciate that. So what I've looked around, and the specific place where I work, we just have 4 or 5 lights. I think that if we could switch those out, that's where I spend most of my time. So I'm pretty sure that would work. And I've got a quote for how much the light bulbs would cost, because I had to put these in at my house as well. And it's only like $25 to change out those 5 light bulbs.
Okay, well that doesn't sound bad, but I mean, having different lights in one part of the office might be distracting for other people.
That's a really good point. Well, one thing we could do is just try it. And we could keep the other light bulbs, and then if it's still a problem, then maybe we can talk about another solution after we give it a try.
Well, you're doing a great job, and we want to do what we can to keep you around, and certainly don't want you going home sick every couple of days because of a headache. But I'm going to need to think about all of this.
Sure. Yeah, I'm happy for you to do that. If you have any other ideas, this Canadian Brain Injury pamphlet has a lot of different options. I looked at them all. I thought the light bulb one was probably the cheapest and easiest, but you can definitely let me know if you have any other questions, and maybe could I come back, tomorrow, maybe again at 9 a.m. and we could talk about it again once you've had a chance to think about it?
Sure, I'll read over this today and we can talk again tomorrow.
Awesome, thank you.
Okay, thanks, Sarah.
So, a little bit better. Yeah. So I'm positive about. Yeah, I'm starting the meeting off in a positive way, as opposed to starting the meeting off by asking for something.
And that softened me up and got me thinking about the fact that I'm hearing that Sarah is a great employee too, and puts me in the mindset of, remembering how valuable she is as an employee and what a great contributor she is.
Yeah, so I think overall, probably tomorrow morning's meeting is going to be successful. Maybe Laura might ask me for some medical information. I didn't offer that up because I thought what I'm asking for is pretty straightforward and it's not very complex. If you were asking for something more complicated, you might want to come with some more medical information. I'm giving her some general information. I also don't want Laura to think because I have post-concussion syndrome that I'm going to have a whole bunch of other problems, right? So I tried to make it very clear that this is not causing me other problems. I'm able to do my work, and it's just this one thing that needs to change. So that was very strategic as well, is just to focus in on the one thing that's impacting me at work and make it easy for her to say yes, because it's just one thing and it only costs $25, and we can try it and easily switch back. It's changing light bulbs. We've simplified the example, and I don't want to minimize that asking for an accommodation when you are not able-bodied is probably a lot more complicated than changing a light bulb. But just to give a simple example, I think you could use the same kind of communication strategy to deal with something more complex as well. Let's say tomorrow I go back and Laura says, you know what, I'm really not thinking this is going to work, and I'm not really sure how a light bulb is going to make a difference for you.
Yeah, maybe I'm like, everybody gets headaches. I don't
yeah, so
understand
then I
how
might
the
say,
lights can
hey,
be
you know what? How
included.
about I bring in a note from my doctor that explains what it is that I need here a little bit better. I might offer that up. At that point, that's that's giving me a little more bargaining power, I would say, because it's adding to the seriousness of it. You might not need to do that, but if you do, like I was sort of reserving that strategically for step 2. I was going to say, like, step 1, let's see if she'll just agree. If I need more, or if I was asking for something maybe that cost $2,500 instead of $25 or required a permanent change to the workplace, then I think you might need a doctor's note. And Laura, as an employer, would have to put quite a bit of weight into that doctor's note. There's some law that says, you know, your own doctor is in the best position to assess you and to talk about what your medical needs are.
And I think as the employer, I'd be within my rights to request that before, you know, even before spending $25 to replace light bulbs, whether I would or not.
Yeah.
Yeah, I think strategically it's wise to do it in that kind of stepped approach, but Sarah also could have come with a doctor's note right off the bat if that was how
and
she
you know,
felt
it would probably
go
depend
best.
on Laura, right? And
Yeah.
that's what I'm saying, like, know who you're talking to, and if I know that Laura's a stickler for doctor's notes, or maybe Laura's, you know, partner is a doctor, or she really likes doctors. I think of everything when I'm deciding on strategy. It's like, what is going to work best for her? I know Laura is just like a nice, understanding person and puts things in perspective and will see my value. So I didn't feel I needed to do that, but I might, with someone else, I might think, okay, I need to be a little more rigid because they're a little more rigid. And so always thinking about who you're talking to. Still now, we only have a tribunal. The commission hasn't started yet. And so there will be some changes coming with that, which will include more proactive outreach. So things like this might be part of the commission's new mandate. We will be out of work. I think volunteers will never be out of work. Yeah. But I haven't heard anything about the grounds of changing. There's now 1 year to file a complaint instead of 6 months, so that was a change that came recently. I have often thought that physical and mental disability are hard. Like defining the separation between those things to me has always been a bit confusing, because I think disability is health related and your brain is part of your body, so it's hard to say what's physical and what's mental. I don't know that those are really that valuable, but I'm not rewriting the Human Rights Code, so have you heard of any changes?
I haven't heard of any changes to the Human Rights Code other than the ones that you just talked about, Sarah, changing the limitation period from 6 months to a year. So you used to have to file your human rights complaint within 6 months, but in November of last year, the law changed to give people a full year to file their complaint. So that's, I think, a good change from the perspective of people that may have experienced discrimination. And then the other change to BC's human rights law is to create the commission. And what the commission will do is hopefully add to our human rights tools here in BC. They'll do lots of education work. They'll make recommendations for ways that laws and policies could shift to better protect the rights of people with disabilities and other people who are protected under the Human Rights Code. I'm not aware of any plans to reduce human rights protections for people with disabilities or anybody else. I am not very knowledgeable about, but aware of new federal accessibility legislation. The Canadian federal government has, I believe, just passed an accessibility law for Canada. And I don't understand it to have impacts on the kinds of things that we're talking about in these workshops. As far as I understand, it will apply in federal sectors, and I think is intended to provide better protection for people with disabilities than what currently exists. But people will also still, as far as I know, have access to the Canadian human rights complaint process. if their issue arises in one of those federal areas. And of course still have access to the BC human rights complaint process as well. What the federal human rights system, like what the difference is. So we talked about how the Charter of Rights and Freedoms is a really important human rights law, but it only applies to governments. So it doesn't give us protection in our kind of day-to-day lives, in our jobs, in our tenancies, and so forth. But the Federal Human Rights Act, the Canadian Human Rights Act, protects people from discrimination if their job is a federal job, like the RCMP, or airlines are federal. So if you worked for Air Canada and you were getting sexually harassed on the job, let's say, your complaint would go to the Canadian, the federal system. Or if you worked for Bell Canada, a telecommunications company, that's another area that would go under the federal system. And then under the provincial system is pretty much everything else. And that's what we focused on for most of the workshops, is people that work in provincially regulated jobs, or have tenancies here in BC, or are accessing services in BC and have experienced discrimination in that context. So that's kind of the difference. It just depends on whether we're talking about a federally regulated service or a workplace, or a provincially. If you think you have experienced discrimination, where can you go for free legal advice? The options are A, the BC Human Rights Tribunal, B, the BC Human Rights Clinic, C, the BC Human Rights Commission, or D, a lawyer at an employment law firm. What the most correct answer? At the BC Human Rights Clinic, where I work, we provide free legal information and legal advice to people who have questions about the human rights process, or questions about things that they're dealing with. Do you remember what day our drop-in clinic runs on? It's Monday. Yeah, we have a drop-in on Monday. People can come for a half an hour of free advice and information on Mondays. No matter what stage of the process they're at, no matter what their income is, anybody can come for that appointment. And if you can't come in person, we'll figure out a way to provide you some support and service over the phone, or by Skype, or by email, if coming downtown is a problem or a challenge. And people can also apply for representation from us as well. So we've got lawyers and advocates at the Human Rights Clinic that can represent people at different stages of the process. I will just say a couple things about the other, Human Rights Clinic is correct. The other sources, so the Human Rights Tribunal, you can't get legal advice there, but their website is a really good source of information. So you can go to the BC, it's BCHRT, is the website, .bc.ca, I think, and learn all about different issues in human rights law. You can link to decisions that the Human Rights Tribunal has made in other cases. They'll tell you about how to prepare for a mediation if that's where your complaint is going. You can access all of the forms that you need there to start your complaint, and do different things along the way with your complaint. So it's a really useful source of information. And if you do file a complaint, you'll be assigned a case manager. Again, they can't give you advice, but they're really helpful people that can sort of explain the process to you and tell you what you have to do as the case goes along. The Human Rights Commission, again, it's not up and running yet, so you can't go there yet, but I expect that when it is, it'll also be a really good source of information and material to learn about human rights from. And a lawyer at an employment law firm. Sarah, maybe you could say a little bit about what somebody might be able to receive if they brought a problem forward to somebody in private practice at a law firm such as yourself. What would they
Well, I mean,
expect?
if you took out the word free from the first sentence, then D would be the right answer. We give a lot of advice on human rights issues, and generally you're going to pay for that. The ways lawyers charge really vary. Some of them will charge you by the hour. At our firm, we do a flat fee initial consultation where we work through things with people and get them on a path to move forward. There's lots of different ways you can use lawyers. I think sometimes cost is always a big worry, and I think that's a legitimate worry. So what I always say is don't be afraid to ask how much it's going to cost. That's a totally legitimate question to ask from the outset, and make sure you feel comfortable that you understand that. And also, you might not need the lawyer to do everything. So they have things they call them limited scope retainers, and all that means is we might just do a piece, like help you with a part of it. So I'll have clients, for instance, who I might help draft a complaint, or they write the complaint and bring it to me to look over before they file it. And then they just use me as a resource to call for advice along the way. Like, I'm going to a mediation, I'm not sure what I should ask for or what might be reasonable, and I'll just help them out with that, and then they can go on their own. And that's a lot more cost effective than having me do the whole case for them. And some people don't need that. So there's lots of different ways to work with lawyers, I guess, is what I would say about that. And there's a number of great lawyers, my firm included, who specialize in.
Question number 2. Who may be responsible for discrimination in the workplace? A, your boss. B, a coworker. C, the company itself. D, customer.
I think it depends in this slide on how you define the word responsible.
Yeah.
Because we are all responsible for our own actions, and if a customer is coming in and dealing with someone and making discriminatory comments, or refusing to work with someone, then in my view you could say they're responsible for discrimination because they are the one that's doing the discriminating. I think that what the point of this slide is to talk more about legal responsibility, which I always say the law and common sense don't always add up perfectly. There can be a little bit of a gap.
Yeah.
And so it's who can you bring a human rights complaint against, and who is responsible for fixing or remedying the situation that's come up. And I think when we're talking about employment discrimination and discrimination at work related to work, in the vast majority of cases, the company is going to be named as responsible because they are responsible for maintaining a workplace that's free of harassment. I certainly see many cases where bosses and coworkers are also named. And I think there is some law that recognizes that a corporation can't discriminate. So, like, I'm just using Walmart as a corporation everyone can identify. So can Walmart discriminate against someone? Well, what is Walmart? Walmart's a legal entity. It is people within Walmart that would be actually the ones making the decisions that are discriminatory. So often, not always, it can be appropriate to name individuals. The reality is it's often the corporation that's going to be providing the remedy in terms of whether there's a financial payment or some changes. They'll be the one that's responsible for the remedy in terms of making that.
And when we talked about this, we talked about how the buck stops with the company, with the ultimate employer. They are, you're right, responsible is maybe a little bit vague, but legally responsible or legally potentially liable for discrimination or harassment, even if that's conducted by somebody else, by a coworker or some other staff person. And actually, they're also potentially liable if the harassment or discrimination is coming from a customer, right? That customer individually might not be somebody that you would name in a human rights complaint, and while they're responsible for their behavior, they may not be legally responsible to compensate for their discriminatory actions. But if that kind of harassment or discrimination is happening from a customer to, let's say, a server in a restaurant, for example, the company, the business running that restaurant is ultimately responsible for protecting their staff and making sure that they don't have to endure working in a discriminatory or harassing kind of work environment. So it's the employer's duty to provide a discrimination-free workplace and to take concrete and meaningful steps to ensure that their staff have the opportunity to work free of discrimination and harassment. And employees that are doing their job and maybe carrying out an action that ultimately is found to be discriminatory. Let's say your supervisor is the one that calls you up and tells you that you're fired the day after you announce you're pregnant. You might make a discrimination complaint on the basis of discrimination on the basis of pregnancy, and the tribunal might agree, yes, that was discriminatory, but the person who called you to relay that news, they wouldn't be individually responsible for that because they're just acting in the course of their job duties. So sort of starts and ends with the company itself, but if somebody is acting way outside of their job description, for example, they're harassing or bullying people, then it may be right that they be individually held responsible, legally responsible for that behavior. So that's kind of the distinction. Are they just acting as part of their job duties, or are they kind of way outside of the usual job description, which in my experience doesn't generally include harassing and discriminating against other people. Which law protects us from workplace discrimination in BC? The Canadian Human Rights Act, the BC Human Rights Code, the Canadian Charter of Rights and Freedoms, or the Employment Standards Act? How many people say A, the Canadian Human Rights Act? How many people say B, the Human Rights Code? Okay, Canadian Charter of Rights and Freedoms, Employment Standards Act.
We had the majority was B, which is the winner.
Yay!
Employment standards is something I find a lot of people, it's confusing. Like, it's a confusing title in terms of what they cover, and in the way that our workplace is legislated, like the laws that apply in BC, it's pretty fragmented. So there's a bunch of different laws, each of which deal with their own discrete issue, but sometimes there can be overlap between all of them. So Employment Standards Act, it protects minimum standards for workers in BC. So it deals with things like hours of work and overtime and statutory holidays. It does, but there are some overlap. For instance, it deals with protected leaves. So there's a requirement to provide a maternity leave or parental leave and pregnancy leave rather in the Employment Standards Act. Well, pregnancy is also covered by the Human Rights Code. So there is some overlap, but in general, I often think of employment standards as more like numerical. And sort of like I always have to get out my calculator right away. If we're talking about employment standards issue, is like, have they paid the right percentage of vacation pay and those kinds of things, whereas human rights deals with, it is a rights-based analysis as opposed to a standard, which is more quantitative, I would say. That's how I think about it. Yeah. There's a lot of good information about the Employment Standards Act online as well. They have a very good website.
Yeah, not to say, like, not to diminish the importance of the Employment Standards Act at all. It's really important in terms of making sure that those minimum standards are adhered to and that workers are paid properly and given the right time off and all of those kinds of really important things.
And A and C could also apply if you were having workplace discrimination at working for a telecommunications company or a bank in BC. Mm-hmm. So, but the vast majority of BC workers are covered by the BC Human Rights Code.
And we talked about other sources of human rights law as well, like the Charter of Rights and Freedoms, and also international human rights law. I sometimes think that, you know, there's a, as you were saying about the word responsible, there's the way that we use that term in everyday conversation and the way we might be talking about that word when we're talking about legal responsibility. And I think human rights, it's maybe the same. we use the phrase human rights in general conversation all the time, and I think what we're thinking about is this big. And then when we're talking about human rights as they're protected by the Human Rights Code, maybe we're talking about something that's more this big. So I like to just recognize that international human rights law protects things at this level, and the BC Human Rights Code is protecting a narrower category of human rights than what we often are thinking about when we think about the right to housing and the right to clean water and food and adequate standard of living and those bigger picture human rights. Next, where would you go to file a formal complaint about workplace discrimination in BC? The Employment Standards Tribunal, the Discrimination Tribunal, the Workers' Compensation Tribunal, or the Human Rights Tribunal?
Here's some mutterings.
Some mutterings?
Some mutterings of D, that's what I hear.
Excellent. That, of course, is the correct answer. The Employment Standards Tribunal is where you would go if you believed there had been a violation of the Employment Standards Act that Sara was telling us about. You weren't paid out your vacation properly. You weren't receiving proper minimum wage for your work. Those kinds of complaints might go to the Employment Standards Tribunal. There's no such thing as a discrimination tribunal.
Until once I started laughing.
We have been talking about it as like a court. It's not officially a court. It's what's called an administrative tribunal. But for our purposes, you can certainly think of it as like a court, and it hears and decides complaints about discrimination. It's free to use. There's no filing fee, no cost associated with starting a complaint. And one of the great things about the Human Rights Tribunal, I think, is that it offers free mediation services. So if both parties, the complainant and the respondent, are interested in trying to settle their complaint, the tribunal will provide a space for that to happen. They'll provide a mediator to help facilitate that and work with the parties to see if they can come up with a resolution of the complaint that everybody can live with. Yeah.
How like effective are they for like enforcing their decisions?
So
What happens if we don't?
right, what happens if the party who's ordered to do something doesn't do it? The way to enforce a decision from the Human Rights Tribunal requires you to go to court to enforce it. You have to start a court action in BC Supreme Court and say, we got this order from the Human Rights Tribunal. They said the respondent has to do these things, and they haven't done it. And that's how that enforcement works. So the tribunal doesn't have its own like internal enforcement system. I don't know about your experience, Sarah. In my experience, people comply with orders of the tribunal.
I have to
in general.
say I don't have a lot of experience in that because so very few things go to a hearing where there's a final decision. In the vast majority of cases, there's a mediated agreement between the parties. And in mediated agreements, I find there is very good follow through. And I think in part that's because they have agreed to that, as opposed to an order just being made where you don't have a say in that, right? So hopefully if you're agreeing to something, it's something you're willing and prepared to do. And my experience has been that parties follow through with that. I just want to back up and make a couple of points here. One being the complaint process. So the complaint process, in my view, they've done a very good job of revamping that in the last year or so to make it a lot more easy to complete the forms. So you can do it online, you could do it on paper. I sometimes will have a client come to me after they filed a complaint and it's been accepted, or I'm acting for the company and so they're getting a complaint, and I find they certainly don't require perfection in how you would fill those out, and they're willing to sort of look at things that may not be put in the right box, for instance, on the form. So I think they do a very good job, sometimes I think too good of a job when I'm on for the company, and letting people, making sure people can access the complaint system. And on the mediation, one point you made, Laura, is both sides have to be prepared to do it and agree to do it. One thing the tribunal does is really push people hard to do it. So you might think, well, I filed a complaint and the company's never going to want to agree to mediate. Well, if you tell the Human Rights Tribunal that you really would like to mediate, you can count on them to try to push the other party to consider that. They can't force anyone to go, but they really do encourage it and promote it and try to really do what they can to get everyone to come to a mediation. And that's because they're so successful. They have a very high success ratio in settling complaints through that process.
Yeah, just by way of illustration, the Human Rights Tribunal puts out an annual report every year, and they report on their statistics. The one for this previous year is probably coming out really soon, but
Monday.
Is it coming out on Monday?
Monday.
All right. Last year's showed that I believe there were 12 hearings and 12 final decisions and orders from the tribunal, I guess orders in the successful complaints. And that's out of well over 1,000 complaints being filed. Only 12 were actually went all the way to a hearing and had a decision from the tribunal. So that means that the vast majority are resolving through mediation, or some get filtered out and dismissed along the way, but I would say that most human rights complaints, by far most, like the vast majority, end up with a mediated resolution.
I had made a cost application once that Laura knows about that I lost. I'm still heartbroken over having not finished licking my wounds. So if I can't get costs for my clients, you know it's very rare.
It's a really good application.
So Transport Canada, first of all, would be federal. So that, and it may or may not have been a human rights case that you were reading about. So human rights doesn't.
I think what happened in that case, it was in damages.
Oh, okay.
Yeah.
So
the
human
difference
rights doesn't have costs, what costs mean is if you hire a lawyer, the money you've paid to the lawyer or some part of that. So that's what costs means. And if you go to court, for instance, like we were talking about, like going after a charter claim in court, that the winner in court generally gets some of their costs awarded. And that's all great when you're the winner, but when you're the loser, that means you have to pay the costs. Like those costs come from somewhere, and that comes from the person that lost. And so the way our human rights system is set up is nobody gets cost awards. And what that means practically is if you're a person who's thinking about making a complaint, you don't have to worry that you're gonna have to pay the other side's legal costs if you can't prove that you were discriminated against. So the same reason why there's no filing fees. Like in court, you have to pay to file your claim in court. So the human rights system is set up to be very accessible and have as few barriers as possible for people to bring their complaints forward. So no filing fees and no risk that if you can't prove, just because you can't prove you were discriminated doesn't mean that you weren't discriminated against. It just means you can't prove it. And so the idea being you shouldn't have a risk of, well, if I can't prove this, then I might have to pay $20,000 in legal costs to the other side, because that would mean people would be less likely to bring a complaint forward if there were risks. So that's what cost awards mean. Damages are something different, and there's different kinds of remedies and different kinds of, buckets of money generally that are awarded in all sorts of different claims. I don't know the details of the one you were thinking about, but it may have been injury to dignity damages. There is one exception, and that's why this says rare, and that's where there's special costs. So the application I was making that I lost for was to try to get special costs, and that only applies where the other party has misconducted itself, in the course of the dealing with the complaint. So where I've seen that awarded has been where people have lied to the tribunal, given false evidence, for instance, That has attracted special costs, but it has to be pretty extreme, like very extreme, to get that kind of award, because the whole fundamental idea of the system is that costs don't apply. So you really have to, it's really unusual to get out of that. So that means if you hire a lawyer, you have to pay your lawyer, and if you lose or you win, it doesn't matter, you still have to pay your lawyer. There's no, you're not ever, that people often say, well, if I win, aren't I gonna get, isn't the other side gonna have to pay your fees? And I say, no, that's not part of the process here.
And I'll just pick up on and reiterate the point that costs are really different from compensation. So the case that you're referring to, that person, he wasn't hired for a job for a discriminatory reason because he had a mental health issue, right? And so he didn't get this job and made a human rights complaint about it, and he was successful. And the employer was ordered to compensate him for all of the wages that he was out, because he should have been hired. He was the most qualified for the job, and it was really clear that the reason he didn't get the job was that the employer was worried how his mental health issue would impact him on the job. So he got compensation for lost wages, as well as what Sara referred to, compensation for injury to dignity, which is the harder to quantify, but the pain and suffering kind of compensation that the Human Rights Tribunal can award. That's meant to acknowledge the harm and hurt that discrimination does to people who experience it, and award them some amount of money to help try to compensate for that harm and that hurt. So the compensation gets paid by the respondent, by the company or whoever has been found to have discriminated, to the other side. But costs are different, and I know it's confusing because we use similar kinds of words to describe really different things, but costs, as Sarah's explained, are the legal costs, and those are really rare in the tribunal context. But compensation, on the other hand, is really common, and a successful case, a case where the complainant is able to prove that they were discriminated against, almost always results in some compensation being awarded to the complainant from the respondent. True or false? Oh, these are true or false. Maybe we'll do a couple. We'll see how it goes. True or false? Discrimination involves treating someone badly on the basis of their disability or some other protected characteristic. How many people say true? How many people say false? Yeah, this is true. I mean, discrimination is one of those big terms. We could probably come up with other ways to explain or define it, but that's not a bad definition, I think, of discrimination. We talked about some examples of discrimination, some things that might count as discrimination, but it really comes down to treating someone differently, badly, or imposing some kind of negative impact or consequence on someone because of a characteristic that they have that's protected from discrimination by the human rights. And we talked about different kinds of discrimination. So the more obvious kind of discrimination, where the protected characteristic, whether it's someone's race or disability or sex or sexual orientation or whatever it happens to be, is clearly the reason that they're being treated badly. And then the kind of harder to spot forms of discrimination, which are called indirect or adverse effect discrimination, where we look at the effect of some maybe neutral policy or rule or requirement that applies to everyone equally, doesn't single anybody out on the basis of their sex or sexual orientation or race or disability. But when we look at the effects of how that policy plays out in real life, we see that it does have a disadvantaging impact on some people on the basis of a protected characteristic. If the person did not intend to discriminate against you, let's say you've made a human rights complaint, your human rights complaint will be dismissed by the Human Rights Tribunal. You can't make a human rights complaint if the person didn't intend to discriminate. How many people say true? How many people say false? Okay, good job. That is false. Intention to discriminate is not the test. That's not what the tribunal thinks is most important about discrimination. And that, I think, fits with the last point about looking at effects of discrimination. Does anybody remember Ms. O'Malley working at Sears, talking about that case? If you remember Ms. O'Malley, she was a Seventh-day Adventist, and her religion her religious practices and beliefs said that she couldn't work on Saturdays. And her employer, Sears, says, but I have a rule that requires everybody to be available to work on Saturdays. And he didn't intend to discriminate against her. He didn't intend to disadvantage people of her particular faith, but the effect was she wasn't able to work at Sears anymore, and she was terminated. And so his intention, or the employer's intention, was not the end of the story. The court said, no, we have to look at the effect, the impact of having a rule like this. And the effect is that Ms. O'Malley suffers a disadvantage, and it's connected to an important personal characteristic, her religion. And therefore, it's discriminatory unless the employer can justify it as necessary for their business. And in Ms. O'Malley's case, the court said, no, we think that the employer in this case could make an exception without it being what's called an undue hardship. We'll get to that one in a minute. And accommodate Ms. O'Malley by allowing her to have Saturdays off. Sometimes treating people the same actually reinforces discrimination, and sometimes we need to treat people differently in order to bring about that effect, the outcome that we want. Employers may have to adjust the workplace to accommodate employees with disabilities. Exactly, that is the essence of what human rights law is all about, and the duty to accommodate. Employers might have to make some changes to the job or to the work environment so that people with disabilities can thrive in the workplace. True or false? Accommodating an employee with a disability is costly and will be bad for the employer's bottom line. True or false? Totally false. And we have some really helpful research that's been done over the last couple of years that really helps illustrate the point from an economic perspective. Obviously from a justice and equality and equity and fairness and right thing to do perspective, we know that accommodation is important, and now we have data that also shows that from a business sense, it's important and good business to accommodate employees with disabilities. A study from last year shows that the benefits outweigh the costs for workplaces that accommodate people with mental illnesses because they're not losing great employees who are not being supported. They have to train a bunch of new employees to come in and take over when they lose those great employees. They're accommodating people on the job rather than having people consuming sick benefits. Now, how far does an employer have to go with those accommodations? A, the employer must give the employee exactly what she asks for. B, the employer must ignore all other business considerations to accommodate the employee. C, the employer must create an entirely new position for the employee. D, the employer must accommodate the employee to the point of undue hardship. I keep putting the right answer as the last one. How far does the employer have to go? They have to do everything reasonable, everything that's reasonable for them to do. What they don't have to do is incur what's called an undue hardship. You might have to incur a little bit of hardship, some hardship, but not an undue or an unreasonable hardship. They don't have to spend so much money to accommodate an employee that they go out of business, for example. But they do have to maybe spend some money or otherwise, have a bit of inconvenience or reprioritize in order to make sure that an employee with a disability has the accommodations that they need to do their job. A couple of the answers that everyone rejected, I could tell, around giving the employee exactly what she wants. We talked about how a reasonable accommodation is not necessarily the perfect accommodation. Sometimes an employee knows exactly what accommodation they would like, and they're really inflexible about what they're willing to accept, and that can lead to problems sometimes because what the employer is willing to do might be perfectly reasonable. It's just not the perfect solution that the employee is looking for. And accommodations relate to things that an employee needs, not necessarily what they just would prefer. So not always the perfect solution, but a reasonable solution that works for everybody. Who suffered an injury that permanently prevented them from doing the job they'd been hired to do. Probably false. Probably default at false, but how many times in your legal advice giving, Sarah, do you say it depends to people? It's sort of the lawyer's like get out of jail free card. We say it, I say it all the time. It can be really difficult to give concrete answers. Like, yes, you're definitely going to win your human rights complaint, or no, you have no chance of winning. Often it depends on all of the evidence and how things come out.
I think too that especially applies in human rights, because we always have to look at the individual situation. And when employers and companies get themselves in trouble with human rights, it's often by they want blanket rules and to do things, have an answer, but they're not considering maybe the specific individual within that. So I think even more than in other areas of law, it depends a lot.
Yeah, for sure. What human rights decisions from the past have said, and this is the best place for us as human rights lawyers to go to get guidance so we can advise people on their issue, is that it is reasonable for an employer to expect certain things from their employees. And if somebody is hired to do a particular job and they're not capable of doing that job, then it may not be discriminatory to terminate them from that job. It's legitimate to require someone to be able to fulfill the essential functions of the job that they've been hired to do. However, and this is where the it depends comes in, a person can only be considered incapable of doing the job if their disability-related needs can't be accommodated in some way without the employer having an undue hardship in providing those accommodations. So we've seen cases where somebody has, been off on a sick leave for a really long time. Their doctor says it's just not looking like they're going to be able to come back to work anytime soon, really not sure when she's going to be ready to come back to work. And the employer has accommodated for months and months and months, if not years, and the workers tried to come back to work and been accommodated and it hasn't worked out, and they've gone back on sick leave, and ultimately the employer has said, we've tried to make it work, but we're going to have to terminate you now. And when somebody has brought a human rights complaint forward in that kind of a situation, where there have been good faith and significant efforts to accommodate over a long period of time, but the evidence is that they're just not able to fulfill the functions of the job right now, and it doesn't look like they will be anytime soon, the employer was justified in terminating them. Even though they were off sick, they had a disability, getting terminated is, an awful thing to have happen to you, especially when it's because of your disability. But when accommodation efforts had been going on for such a long time and the person just wasn't able to come back and do the job, the termination was upheld and found not to be discriminatory. So it really depends.